Hi, everybody. This is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and this is Raw Law. So, this is the channel and the show where we answer your questions live. You can come on and leave a comment, and we'll read your comment and try to give you the best answer from me, personal injury trial attorney. So, while we wait for people to join and start asking questions, I'm just going to maybe go into the channel and answer some questions that we've had from last week or from this week. Just kind of go into the channel a little bit and see what's going on, because last week I was on trial, so I was away, and I think I did do a raw law on Friday. So we talked a little bit about what happened on Friday, and we ended up settling the case, and we got a pretty good result. That case had a $140,000 offer for the longest time, and it ended up settling for 3.1 million, 3,100,000. So it was like, what is that, 20 or 30 times out, 30 times 100,000 offer. So it was good. It was good. The client was really happy, and I think it was fair. And I think I talked about it before. It was good because, like, if we didn't settle, we couldn't get a trial date just because the court didn't have the ability to give us a trial. And the reason was just because the judges were all going to like a seminar. And then when the judge came back, the one we got, even if we waited for him for a week to be at the seminar, he was going on vacation after July 4th. So we didn't have a judge. So what are we going to do without a judge, And then we had to wait until July or August, who knows? So that was just really more of an administrative problem with the court. But practically, even if we had gone to trial, and it was a complicated trial, we would have needed a 3-week trial. We had 8 before and after witnesses from the client's life to talk about how she was before, how she changed because of the traumatic brain injury. We also had 6 experts. So, like, you have all these experts, neuroradiologists, neuropsychologists, life care planners, people. We had her, I think her grandfather was going to testify, because he was a pastor at the church, and she used to go to the church and she used to participate. It was an African-American church. She used to sing and listen to all the people. It was, a lot of people in the church. After the brain injury, she can't go in there. She goes in there, she hears the sounds, she has to leave. She sees, she can't take the lights, sounds. She just has to leave. Like, she takes her son to the movies because her son loves the movies, and she has to get, like, she's on the 5th bag of popcorn, not because she loves popcorn, because she can't do the lights and the sounds. It's like phonophobia is the sound and photophobia is the light. You can't do it with a brain injury. She has to leave, and she keeps, her excuses, I'm going to get more popcorn. She comes back, like, she keeps doing it, like 5 bags of popcorn. So we had all this evidence, right? But the point is, if we would have tried the case, it would have taken like 3 weeks. And if we would have gotten a bigger number, like 17 million, right, whatever. But then the problem is they would have appealed, and the appeal would have taken like 5 years, and then the appellate division would have just reduced it to like 2 or 3, because we checked what's sustainable, and sustainable is only like the highest we saw was like 3.5, and we got 3.1, and the 3.5 was for a labor law case where the guy had like millions of lost wages, which we didn't have any lost wages, so it was a good result. But anyway, let me get to your questions. Lucky is here. He or she says, "Hi, Arkady. Hi, how are you? Thank you for being here." And Money Dog asks, question, what would you tell your attorney that lowballs your case after waiting for years? Well, I mean, look, you got to tell him or her, what you want, because remember, my whole thing is an attorney is a guide, right? You are the client. It's your case. You could have attorney A or attorney B. Today I could have Pepsi. Tomorrow I'll get a Coke. It's a free country. If the attorney's not doing something for you, they're not performing their service. So just get another attorney, or, speak to them. If they are really a trial attorney, then, why are they lowballing your case? Maybe they have a good reason, right, to lowball your case. Maybe the case can't be won for more than 100,000 because there was some problem. And that's also legitimate, right? If the attorney goes to court, they could be the best attorney in the world. But if the case has some problem, like there's credibility issue, there's liability issue, but maybe the client could be at fault, there could be a lot of different problems, and then the case is lost. You don't want to get 0, so you always have to be thinking like, how do I get the most money? Like in my case, right? I could have gotten 20 million, but it's just a piece of paper. I'm never going to see the actual money because New York has remitter. They're just going to knock it down, and that's going to take like 3 or 5 years. So 3.1 is actual money the client's going to get. So, your question is very general, but that's basically my answer. Like, I would speak to the attorney, I would make an appointment, go into his or her office, sit down, ask them all the questions. But if you feel like, look, they're just lowballing your case, and your case is really a good case and it's worth more, and it's because the attorney's lowballing it, maybe because they're not a trial attorney, there's a lot of different possibilities, right? Like today I did a consult with somebody, really nice person. They just called me out of the blue. I just picked up, we didn't have a scheduled appointment, and I chatted with a gentleman. He was from Chicago, and he was telling me about some lawyer. And look, I went to the lawyer's website, beautiful website, pictures, all these people, looks like the senior lawyer. And then there's another lawyer that's even more senior. They look like, Clark Kent, whatever, like super senior. I looked them up for him while we were on the call. Zero verdicts, 0, no verdicts at all. So that's it. That's a red flag. The person's never been in court. So what are they going to do? Like in my case, right? If it was that lawyer handling my case, they give the guy that's what I had, $145,000 offer. What is he going to do? How is he going to get to the 3.1? He's not, right? He's just going to take the 140. If you don't have the hammer to go to court to make them pay more, you have to take the 140 or whatever they're offering you. What are you going to do? You have no tools to get more. So that's the whole thing, right? That's kind of like why I'm trying to help people. I say, text me, give me the name of your lawyer. I could run the search. If they're a real trial lawyer, stay with them. I'm not trying to take cases from other lawyers. Stay with them. I'd rather have a few cases that I could work on, fresh cases, new cases from people who got injured that know me and come to me directly. But look, if you are in this position where you're underwater because you have like one of these billboard lawyers or somebody who just doesn't go to court, well, then I'm happy to help you if you need the help. If you see, hey, this lawyer never goes to court or gets zero, then I could help you. I could find somebody in your city that actually does go to court and gets top results. So that's one of the services that I provide. And another lady texted me today. She has a TBI case in Florida. Her lawyer, 0 results. And then the main lawyer in the firm has 1 case, and it's for 0.00. So I texted her. She wanted to know. So it's just like information. Sometimes I search lawyers. There's one lawyer I searched, I forgot his name, but out of like North Carolina or South Carolina. And he had like amazing verdicts, 5 million, 7 million, like 20 million. I'm like, whoa, stay with that guy. That guy's like the real deal. But, honestly, I don't see that so often. A lot of the time I see people with, maybe not in the best hands. So that just happens. Okay, and then Crystal says, that's amazing, Arkady. You are the best. Oh, thank you so much. And Paul Dottie says, Arkady, does a judge in workers' comp personal injury case have to okay the settlement amount when it's finalized? I don't believe so, unless you're in a jurisdiction where that could be the rule in your jurisdiction. In New York, we do have to get the consent of the workers' comp carrier. So that's the insurance carrier. We just have to call them and get their written consent to the settlement because they do have a lien. But if they don't consent and there's some kind of issue, then you might have to make a motion and have the judge decide it. But that's the rule in New York. In other jurisdictions, you might have that where the judge may have to give okay the settlement. I don't know, because I don't do workers' comp, so I only do the third-party personal injury. Now, in personal injury, it's pretty rare for the judge to okay the settlement. You could settle for anything. You could settle for $1. You could settle for 100 million. The judge doesn't really get involved. Now, unless it's an infant compromise order, right? Because if it's for an infant, a settlement for a child under 18 years of age, then the judge does have to approve it, and then it goes to the child, to a bank account in the child's name. The guardian or the parent watches the money somehow. But basically, you can't touch money. It grows at the highest rate of interest, and then when the child is 18 and they're an adult, they can take the money then. So that's how that works. And but that's pretty easy. You just go there to a hearing, and you get the different affidavits of doctors, affidavits of why you settled it. It's a whole package. It's called an infant compromise order. And so you file it like a motion, you go to the judge gives the kid a lollipop, talks to you for like 20 minutes. Usually the judge also makes you cut your fee a little bit. You don't want the lawyers to take too much money because it's the kid's money, so you get less of a legal fee, and then they just sign off on it. And Crystal says, especially with no lost wages. Yeah, I think that was good, no lost wages. I mean, we did have like future medical costs, from the Life Care Planner and the Economist, which I recommend to do on cases if you can. And then Brandy says, it's been 7 weeks since I signed my release for my settlement. Why isn't taking so long? Just last week, she said she was doing deductions. Right. So, I mean, that's also, see, like, I can't really tell you exactly, right? Because it's a good question, but there's a lot of different possibilities. It could be that they haven't received a check for whatever reason. It could be that, like, for example, if there's a Medicaid or Medicare lien, that's the federal government. So they won't release the money until that lien is resolved. So that might be like 60 days, 90 days, because it's slow. It's like a bureaucracy. So that could be one possibility. I mean, I hope it's not because the lawyer has the money and they're just lazy or they're not, doing their job and getting you paid. But the only way you could really find out is call them. They should tell you. But it shouldn't be too complicated. I mean, it should be. But that's the only real reason they could delay it is because of liens. Usually, that's the only reason are the liens. I can't really think of any other legitimate reason. Okay. And then Paul says for workers' comp, not the personal injury part. Right, workers' comp. So yeah, I think we answered that. Like in New York, you do have to get consent of the carrier, which is the insurance carrier for the workers' comp that pays the lost wages and the medical bills. But in other states, like, I don't know, we could like look it up, or you could do the ChatGPT thing, Google, whatever. I'm not sure. It could be like in some states you do have to get judge approval. And then Amiri says, can the statute of limitations pressure insurance companies to settle? I'm getting close to the statute of limitations are up in September, and a lawsuit has not been filed, and no offer has been offered by the insurance. Yeah, I mean, definitely, if the statute of limitations could, pressure, I mean, it's more of a pressure to the plaintiff, right? Because if you don't file by the statute, then the case is dismissed. So you should get it filed and don't wait until the last minute. I like to file my cases at least 6 months before the statute, probably even earlier. I mean, there's no reason to really wait. You give them a chance to settle. You could send them a letter, like a settlement opportunity letter. But, to be honest, like, it's rare that they offer substantial amounts, even for a settlement opportunity letter, before you file a lawsuit. Because remember, like, if it's just a claim, they have like a claim adjuster on it. And those are adjusters that only have authority up to like 50,000 or something or less, right? When you file a lawsuit, then you have a litigation adjuster. Then, they have more authority. They could go to the supervisor, maybe you get the full limits and you get into the excess. Like in my case, for example, we had 1 million, that was the policy. So we got that tendered. Then they had another excess policy, and we got 3,100,000 of the excess. We were actually trying to get a little more, like 3.6. And then the judge was telling us, on one day he was going to get us to 3.6, but then he couldn't do it because, they would have needed to go to some kind of supervisor at another level. And they're like, there's no way we're going to be able to get to that level. And then you're going to have to go to trial. And then maybe like a few weeks we could try, but then the client just wanted the money. So that's how the insurance companies work. They go level by level. And that's another reason that they do it, right? Because it protects their money. Like, I only have the ability to give you like X, and if you want more, then you have to go to the next level, and they have stoppers, like many stoppers. That's just how they work. Okay, let me go back to these questions. So then Willie says, hello, my friend. Hi, how are you? Great to see you. And then M says, what do you mean by working up a case? So working up a case is basically like building the case, right? So like if I get a case, what do? I look at the case and I think like, well, do I need an expert? How am I going to prove liability? Do I have photos? Do I have measurements? How am I going to prove damages? Do I have before and after witnesses? How has this person's life been really changed? If I just go in and say I have a broken leg, okay, no one's going to care. So I want to show, hey, this person needs to play soccer. Get a soccer teammate to testify. Now he can't play soccer now. He sits on the couch and watches reruns of Family Feud because his leg is broken, right? You get those people to come to court and kind of paint a picture like a movie. Imagine you're a director, you're Martin Scorsese, right? And you're putting on a movie, like a good movie, like kind of The Godfather or whatever. Who are you going to put first? Who are you going to put second? So it's a whole project. It's a whole project. So that's working up a case, building the case, getting a life care planner, right? Economists, all these things. I mean, there's a lot to it. So you need the experience, you need the ability, but you also need the creativity, right? Like I had a lot of interesting things I was going to do in this case. I was actually going to play a song that I heard by an artist named Celeste. And the lyrics to the song really, I thought, even when I listened to it, I was like shedding a tear. It was like really powerful. I thought the lyrics to the song, it's called "I Can See the Change." And if you listen to the song, it's, you can see maybe you'll like it, maybe you won't. But I thought the song was really good because the song, I thought, really summarized what this client went through. Because she was saying the lyrics, I could pull them up here. I think I even screenshotted them. But basically, the lyrics to the song, let me pull it up here. I screenshotted it. It's called "I Can See the Change." So yeah, things like that. Like, that's like working up a case, right? Like she was basically saying, let me see here. Yeah, here it is. Okay. So she was saying there were some lyrics that I thought were like really, not the whole song, but some lyrics were really powerful. Like, for example, she was saying in the song, "I can see the change, come what may, I won't regret today." So it's kind of like the brain injury, right? You can see the change in the person, and because it's not just a change to their, it's not just a change to their memory, it's a change to everything. It's a change from being happy and being emotionally fine to being depressed, being more of a hermit, staying in your home. And she's saying, "Come what may, I won't regret today. I can see the change. I can feel the pace of everything. Who am I, teary-eyed? Who are you in your life?" And then she was saying, "It's not for me anymore." And she's saying, "I could see the change better than I ever could before. I am what remains." I thought that was powerful. I am what remains. She has a brain injury. She's a different human being, but she is who remains. We can't go back, right? We can't make her the way she was before. All we could do is give her compensation. So I had this whole thing like that. So that's like working up a case too, right? Like a lot of lawyers aren't going to do that, but but I did that like with the theory and with the song, or sometimes it doesn't have to be a song. It could be a poem. It could be your own writing, creativity, but things like that. That's like all building the case, right? That's why you can't take too many cases, right? You have too many cases, you're not going to be able to do everything for all of them. That's why you really, but yeah, that's basically building the case, I would say. It's like working it up, getting everything. And a lot of it is technical too. Like someone else was, Richard, my co-counsel, he was going to try the case with me. He did like 3101Ds, like expert exchanges, right? He did subpoenas. He did, we did consultations together with the experts. We learned a lot. Like I did a consultation with a neuroradiologist. I learned so much. She was saying on an MRI, if it's less than the tip of a pen, right? This tip that you write with, that's 1 millimeter. If it's less than that, it won't show up on an MRI. MRI cannot see that. A 3T MRI cannot see a lesion in the brain that's less than the tip of a pen. So, we had lesions, but they were less than the tip of a pen. So we saw them through neuroquant and icometrics and diffusion tensor imaging. But we didn't have any lesions on the MRI. MRI was normal. And that was one of the arguments the defendants were going to use, right? So things like that. And that we learned from the neuroradiologist, but we also prepped the urologist. He was brilliant. We prepped the neuropsychologist. She was brilliant, right? She was giving us all this thing. So yeah, all these things are working up the case. And then, let me see. Let me get back to your questions. Isaiah says, "Hey, I have a question. If there is $1 million insurance policy and you get rear-ended by a commercial vehicle and you do physical therapy and chiropractor for about 6 months, what do you think the settlement might be?" Right. So no, the amount is going to be dependent on what they find when you do the physical therapies, right? What does the MRI show? If it's just like a herniated disc, but you don't do anything, you don't do any injections, no epidurals, no percutaneous discectomy, nothing. Just you have a herniated disc or a bulging disc. Depending on where you are, it could still be significant, right? You could still get 30,000, 50,000, whatever. If you do an epidural, I think I've said before, I had one case went to like 140,000 with an epidural injection. That's when they do like the pain relief injection, and they inject a steroid so that you have the herniation in the disc, but the steroid just kind of numbs the area so you don't feel the pain. It's kind of like pain relief injection. And so that's like 100, 140, possible. That's one of the high ones. I mean, sometimes people settle them for less than 50. But then if you do the percutaneous, that could even be 200-300, right? That could even be 500. I did one for 548 with Rick. Also, he actually did that case in Manhattan, which is a conservative venue. So, and then if you end up having like surgery, it could be, millions. So it just depends on what you end up doing. So it's not really, getting hit by the car or having the $1 million policy. It's really the injury, the diagnosis that's going to drive value, as well as the overall impact to your life, like these before and after witnesses and how you're in photos, videos, whatever you have, however you can show like how your life has changed. And then M says, do you handle personal injury civil rights cases? Yes, I do. I do handle those. Usually I partner with other firms on those because other lawyers that I work with and I co-counsel with, even here in New York, are more like specialists. Like one of them actually used to work for the city, used to defend those cases, but now for like 20 years, he's doing a lot of the civil rights cases, getting like tremendous verdicts and really good trial lawyers. So I partner with like that lawyer or someone else. But yeah, you can feel free to reach out. Our number is 347 566 9595. So yeah, if you text me, I could I'm happy to help with that. Okay, so we did that one. And then Mr. Cent says, what would you estimate injury, concussion, bulging disc in neck, low back sprain, lingering symptoms of head injury, and tingling down the arms was a pedestrian injured by a tow truck with a $3 million policy? Yeah, I mean, look, that could be a big case if you have a concussion. I mean, a concussion, right, can go away, and then you have no symptoms left. That's one type of concussion. But another concussion is like my case, right? I had a concussion, but it didn't go away. It just like sometimes it has lasting effects. It's called post-concussion syndrome. And then that's kind of similar to a mild traumatic brain injury. And they actually changed the definition of what is a traumatic brain injury. And they're going to get rid of the word mild completely. The mild doesn't really explain what the injury is. The reason they were using mild was because, when the paramedics would get you, they wanted to know, hey, do we need to drain blood from the brain, put in a shunt? Because if we don't drain the blood, if there's hemorrhaging going on inside the brain, the person might die, right? So it's more like for trauma. So they said, well, that's severe if you have bleeding. If you don't have bleeding, it's mild. It doesn't mean it's mild as an injury. It just means it's mild for the paramedic, right, who's rescuing you in those first 5 minutes when you got your head hit. So that's like completely, but the defense bar and the insurance companies, they love that word, mild, everything's. So, I'd have to know more about your actual injury. But yeah, it could be worth money. Sprains, not so much. But if you have symptoms of that injury, sure, that's like my case. I just got 3.1. So you could get, depending if you have a good trial lawyer, it's possible you could get, something into the millions even, depending on if you had like scans or 3T MRIs, diffusion tensor imaging. I like to get neurologist, neuropsychologist, neuroradiologist, those three. Because the radiologist is like just, they read the MRIs and the scans. The neuropsych does the testing to see your functional ability and how you're doing. And then the neurologist is like the overall quarterback for everything. They send you to the other doctors and they do their own testing and they're like the main doctor. So that's how that works. And then Jen says, is anyone having issues with lagging? Your internet seems to be having issues. I don't know. Is anyone else having problems? I think it's okay, but I'm not sure. And then M says, does a competent attorney get records from treating chiropractors or physical therapists, etc.? Well, of course. I mean, what do you mean? You have to get if you don't have the records. Why would you not want the records? Like you're saying, you're saying records exist. The doctor has the records like in his computer or in his shelf somewhere, but your attorney is not getting them. So then how is your attorney going to go to court without the records? What are they going to say? My client has a boo-boo. There are records. They're in the shelf somewhere, but they're not here. They're not in court. I've never seen them. They're in the doctor's office like miles away. You think that's a competent attorney? I don't know. I mean, of course not. You've got to get the record. That's malpractice, actually. Then the attorney could get sued. It says my lawyer isn't doing it. Thanks for these lives. Oh, that's not good. That's a red flag. You might want to reconsider. You might want to call me for a consult. I'll help you. That's not good. Okay, Isaiah says, let's say you have a disc herniation and stuff like that. Yeah, I mean, disc herniation is like one of the most common injuries. And then Mr. Cent says, should I be worried if my attorney isn't asking anything about my personal life or personal story in California? Is it sometimes not relevant to the case? I mean, look, to be honest, most attorneys don't do that, right? But I think it's important because, like, just in my experience, I work with some groups like Trial Lawyers College, Trial by Human. Those guys, they taught me how to ask that, right? How to really do a deep dive, go to the client's house, break bread with them, find out about them, who they are as a human being, who are their friends, who are their family, who are their coworkers. I think that's critical. I don't think you can really do a case without that. I even do that on the small cases. I did it on a case, like $100,000 case. The guy got hit by he was on a bike, he got hit by a car, broke his clavicle, but he had like this, bump in his clavicle. I found out about him, about his daughter, about his life, about his dreams. He was an immigrant, this and that. I come to court. I did a good job for him. We got we got more than the policy. We got like 160, 200. We got wages. We got pain and suffering. They had to give us the entire policy. I mean, yeah, I think you have to do that. It's not a matter of being worried. It's just, but in reality, like most lawyers just don't do that, right? They don't have the time because they're more like into the business of law, right? Like if I'm going to go to everybody's house and have 1,000 clients, well, you can't do it. So you have to find that trial lawyer who doesn't have a lot of cases, who has like maybe 100 files, right? Or even some lawyers are good lawyers. They have like 12 files but each case is like, maybe a $10 million case, but they only have 12 cases, some 10 cases. So, it's just a matter of what you want for yourself and how serious your case is. Okay, and then Shori says, if my attorney sent the demand package on June 11th with 8 months worth of treatment history to farmers, how long does it take for them to respond? Well, I've done questions like that before. Like, see, it depends on how you word the settlement opportunity letters. I don't like the word demand because I feel like, I'm demanding, I'm begging. I say settlement opportunity. I give them the opportunity to settle. I always say you have 30 days. If they need an extension and they're in good faith going to give me what's in my letter, the amount I put in my letter or something close to it, sure, I'll give them another 30 days or whatever extension. But that's why I know what it's going to be due because I put it in the letter. Now, if you just send the demand letter and you just like praying, give me money, and you have no deadline, well, maybe they'll never respond. Maybe they'll just like laugh at it and throw it in the garbage, and you'll be waiting till the cows come home. I can't really tell you. It depends on how they wrote it. But like I would say, I like to do it like that's the way I do it. But like again, like most lawyers don't do it that way. So I can't really, comment on other lawyers because like other lawyers do it their way. Everyone does it their way. It's just like doctors, right? One doctor might be able to do an operation to your brain and then you'll be fine and you'll be healthy. And another doctor might do the same operation and kill you, right? But like, you know what I mean? Or might just not make you better. And it goes for anything, right? Dentists or, it doesn't have to be doctors. It goes for any profession, I guess. There's different people, right? Some people build beautiful houses and some people build houses and they like fall down. So I don't know. Like I can't really comment on other lawyers, but to answer your question, I think that you do have to put some kind of deadline in the letter. Otherwise, or okay, if you don't put a deadline, you send a letter, then you have to get on the phone and say what's happening with the letter and get a status by calling them. But I don't know why you wouldn't put a deadline. Okay, and then M says, do you work up the case before notice of issue is due or after? Both. I mean, I work it up right from the beginning. Like, I just got a file today. Actually, it was a YouTube viewer, and I was reviewing the case, and he came to me. He had another lawyer before, but the lawyer just started on the case, didn't really do anything. The whole file was just like a lawsuit, some medical record. But I started reviewing it. I'm going to review a deep dive this week. It's a big case, and I'm going to work it up. I'm going to get experts. I'm going to get plan to do corporate representative depositions. That's a big deal. It's called 30B6 in federal court, and in state court it's called 20220 in New York. But it's basically because it's a company, any kind of company, organization, corporation, you can ask them, hey, these are the issues, these are the topics I want to talk about. Now you designate a witness, but the witness isn't going to be giving a deposition as an individual. Like, for example, they're not speaking as I'm Joe Blow, they're speaking as the company. So they're speaking as Walmart or Target or Pepsi or whoever you're suing, right? So that's a big deal because then you can get them to talk about safety issues, policies, procedures, like a lot of different topics. And that's the official position of, Walmart or Target. And then you can use that against them at trial. So I do those. A lot of lawyers don't do those at all. So it just depends. But yeah, to answer your question, I mean, I don't want to go off too much on tangents for every question because these questions are good, by the way, but they're just so general that it's hard to answer them. I don't want to go off on too many tangents. But to answer your question, before and after, definitely. After is more like subpoenas, trial prep, and before is more like you're building the whole case, right? What's the case going to be? So like this case, I'm starting it. It's a good example because it just came in. The file just came in. today, and I'm looking at it, and I'm already seeing issues, and I map everything out. I make a case plan, and then that's how we work. And then Virgo says, what happens if the defendant doesn't respond by the 30-day deadline? Oh, to the settlement opportunity? So then it goes up. Like, for example, in my case that I settled for 3.1, originally I wrote them a letter and I put pay me, I think it was 4 million something, and they had until May 9th. And they let May 9th expire, and May 15th they send me an email and they say, oh, we're going to go from 145 up to 250. I was like, thanks, but if you read the letter, it said it was 4 million until May 9th, and now it's 7 million. Then they got all upset, and then they came to court and they were like, I don't know, almost like shaking. They're like, oh my God, that's 7 million. But then we ended up settling, like I said, for 3 because it was enough and the client wanted it. But like I could have gone to court, I could have just stuck to my guns and said no. But that's how I do it. I put it right in the letter, like what's going to happen if the 30 days expires. You just have to put it. Now, it doesn't have to be that dramatic. It could be different, right? It could be 100,000 that you're looking for, and if the 30 days expires, it might go to 150 or whatever you want to do. You could structure it however you want. Okay, and then Jen says, I was hit by a drunk driver driving a company vehicle and sustained a transverse process fracture of my C7 and a TBI back in March of this year. I was deemed not at fault. And how long do you suppose after I am cleared medically it may take to start negotiations and then settle? So you want to get you want to find out how much insurance there is. You probably want to file a lawsuit. You want to, you have a fracture of C7, that's serious. Now a TBI is even more serious. If it happened in March of this year, it's recent. So a case like that, I mean, I don't know where you are, what city, but if you want, just text me. I'm happy to do a free consult. 347-566-9595. That's 347-566-9595. Then I could tell you a lot more information. But a case like that, I wouldn't be hoping for a quick settlement, because if it's a TBI, that's a life-changing, forever injury. It's like your brain is going to be different. Like you can have memory loss, executive functioning. My client had a lot of PTSD, a lot of emotional. Like before, she was going out, doing things. She was modeling. She was actually an extra in a movie. She was in one of the Spider-Man movies. Afterwards, she's just like at home in the dark. She doesn't want to leave, and like her mother has to come to her, and she doesn't even want to go outside. Completely different person. That's a big injury. So yeah, I wouldn't try to settle that. They're going to offer you pennies on the dollar. And then Jennifer says, hi, Arkady, is it possible to sway a historically conservative jury into awarding large damages for serious and permanent injuries with no surgery? Is it worth the risk to try? I mean, that depends. It's possible, right? But you have to have the right case to be able to sway them, right? If you don't have the right case, or if there's, you could try, you could start the trial. But again, if you have a substantial offer, then maybe it doesn't make sense to try, because then you could potentially also get zero, and then you lose the money that you have on the table. So it's always like a cost benefit, analysis. Like in our case, it didn't really make sense because, we had 3 million, and then how much more are we going to get? Even if we get like 17, right? They're just going to knock it down to like 2 or 3, because that's the sustainable. You got to look at what's sustainable also. That's important. So yeah, so usually you just have to kind of take it each case independently on a case-by-case basis. And then Madison says, your attorney will sue the truck company and the insurance company. Yeah, well, usually you just sue the trucking company, and the insurance answers and appears and defends, but you don't usually sue the insurance unless it's like some other, like a bad faith case or some other type of case. And then Drew says 44 in New Jersey, rear-ended, needed ACDF, that's anterior cervical discectomy infusion, and a laminectomy, okay. Bladder incontinence, discovery open until November, scheduled today for an August deposition, $1 million policy with another $1 million in umbrella, settle time value. I mean, that sounds like it's worth the policy, clearly, the full, like the $2 million, because you have ACDF, that's already serious. And then you have TBI, I think you said no, bladder incontinence, that's serious. Bladder is super, and plus you have laminectomy too. So that's super serious. So yeah, I would just get the full $2 million. New Jersey, New Jersey has kind of a little bit, maybe a little more conservative than some parts of New York, but some parts of New Jersey are okay too. The main thing is you want to make sure you have a real trial lawyer who goes to court and gets verdicts. Because if you don't have somebody that gets verdicts, they're going to get pennies on the dollar. You need a verdict lawyer. Like I know in New Jersey, I know a bunch of really good lawyers. Truck accident, whatever, any type of accident, really good lawyers. Actually, we're going to probably be some of our lawyers are already like admitted in New Jersey, so we're probably going to start doing some New Jersey cases too. But I know some amazing lawyers that we can co-counsel with in New Jersey. And Fernando says, "Hi, lawyer. How are you? Nice to see you again." Oh, hi. How are you? Great to see you. And Freddie says, "Good afternoon." Yes, absolutely. And just go back. And then M says, "I'll message you about my PI civil rights 1983 case. I didn't catch the texting number. Mind sharing it again?" Yeah, 347. Let me drop it in the chat too. 347-566-9595. Just text me your name, your city, date of incident, when it happened, brief, like one sentence, like I slipped and fell or whatever, got hit by a car, back in the rear, just one sentence. And then your injury, if you know it, kind of like what people are saying here, like I had an ACDF or whatever, and then I could schedule a call with you. So yeah, absolutely. And then Manny says, "Hi, Arkady, I have to go to an IME. What should I do?" For an IME, I recommend getting one of these watchdogs to go with you. That's good to do. Some states allow you to record the IME or to videotape the IME, but in New York they might not. So if you can't record, if you can't videotape, then the next best thing is to send a watchdog. It's just like somebody, like an observer, right? So the doctor's doing whatever the doctor's doing, and the observer's writing everything down. If you walked in, it was 10:11 a.m. The doctor, checked your range of motion. They moved your hand up, but they didn't have the instrument like the goniometer to actually measure range of motion. Because then later the doctor will write, "Well, I measured it and it was 60 degrees and normal is 90." But wait, or whatever. He's going to say, "No, I measured it and it was 90 and normal is 90. They always say everything's normal. But if he didn't have the instrument to measure the range of motion, he can't eyeball it. It's not medically allowed. It's against the guidelines and there's medical guidelines that you could also cross-examine them on. So that's why I like that. If it's a serious case, if you've got surgery, fractures, I always use this watchdog. It's not expensive. It's like $100 or something, maybe a little more, but it's not expensive. Every lawyer should do that. But a lot of lawyers just send their client to the wolves. Then these people are going to write whatever, but they measured it, that it was normal. But then how are you going to cross-examine them? You don't have any proof of what they actually did because you can't bring a tape recorder or a camcorder into the room and no one else was there. And then your client, they're not going to remember what they did, or you can't even testify to that. They're not going to know what goniometer is, right? So things like that, I would really recommend using a watchdog. And then Nanny also says, "Do I need to know what are the names of all the medications? If I miss one, will this affect?" No, you don't have to know the names of the medications. And then Miguel says, "Hello, Arkady. If you file a lawsuit, for example, today, how long does it take for a date in the Bronx?" You mean like a trial date or an answer? Like an answer, you file a lawsuit, you're going to get an answer to your lawsuit. So meaning the people you're suing, the defendants, are going to appear. That usually takes about 30 days, maybe from when you serve them. So you file it, they don't know you filed it. You have to serve them, meaning bring it to their door and give it to them. From that date, usually it's 30 days. It could be a little more. It could be 60 days, 90 days. You might have to make a default judgment. If they don't answer, then they'll wake up and answer. So, but usually like 30 days. But to get all the way to a trial, you're talking first, you got to do all discovery. Like you have to do depositions, exchange documents, certify as trial ready. And the Bronx has been slow. Sometimes people are waiting 3 years after note of issue. Note of issue is when you certify that all discovery is complete and you're ready for trial. So ideally, right, if you say all discovery is complete, I'm ready for trial, you could get a trial tomorrow, right? But they don't give you a trial tomorrow because there's a lot of cases. It's New York City. But they're going to give you a trial 3 years later, 4 years later. Now, Queens, Manhattan, Brooklyn, maybe a year later, which is still a long time, a year. They took 3, 4 years in the Bronx. The Bronx is slow. And then Red Shadow Cat says, "Hi, Arkady. I had a left shoulder arthroscopic surgery, left knee arthroscopic surgery, and a 1-level fusion. My lawyer said that they have me on surveillance camera shoveling snow. How do you think that will affect my case? They have a $5 million policy." Well, I mean, look, if they have you on camera shoveling snow and you have all these injuries, it's obviously not that good. You'd have to get the video, you'd have to get all the video, everything, right? Including like the outtakes, because they're showing you one video of you shoveling snow, but get everything, because some other parts of the video might show you like, injured, or show other parts, right, that they're not showing. But it's not good, but it doesn't kill the case necessarily. You're probably going to have to, like, what I call front it yourself. Don't wait for them. Don't like be quiet about it. Don't say anything, and then let them. Oh, by the way, this client is shoveling snow. You don't want that, right? Because then it's like you're hiding something, and then they're kind of like, opening the light on the truth, and you look like a liar. So just bring it up yourself. Just say, look, I have to shovel snow. It's where I live. That's what I do. My arthroscopic surgery was painful, but it healed the ligaments that were torn. I had a fusion, but the doctor said I could go back to activity. And, I did, I shoveled snow. And, in terms of liability, I don't know what your case is about, whether it's a car crash or slip and fall. So that's a big thing. And in terms of the injury, I mean, you have the injuries, so it should still be a significant case. Now, whether you get the full 5 million or less, I couldn't say. I don't know where you are and things like that. But yeah, it's definitely not good. I mean, I've had clients also on surveillance, but like I always tell them, just be careful. So the last few trials I've done, like for example, the case where I got 3.5 million on the slip and fall in the Bronx it was like an elevated platform, like the subway, but outside, and he fell down like all these steps, like 30 steps. I told him, be careful. He was careful. They got him, but like, what did they get him doing? Driving a car. Then he stops the car. Then he gets out of the car. He walks around. Then he presses the button on the remote. The back opens. Then he takes like a piece of paper. Then he gets back in the car. Then he drives to like, okay. So you have him on surveillance. Like, who cares? Like, what is that? And then you turn the surveillance around on them and you say, why are you intruding into this person's life? And why are people have an expectation of privacy? But so that's the main thing. Like, you don't want to do something that you said you cannot do. So if you testified in your deposition, you swore, right, and you said, I cannot shovel snow, but then they have you shoveling snow, well, that's not good. But if you never said you couldn't shovel snow, and it's like some light snow, and you're cleaning, your own home because you can't afford to pay anyone else to do it, and your doctor told you can go back to activities, then you're okay. So just kind of like, like anything, it depends on the situation and the context. Like I had another guy, he was just so hurt, he had a fusion too. He was so hurt that he was just confined to his home. He couldn't leave his home. The case is still pending. And they surveilled the guy. And what they did was, because he never leaves his home, they knocked on his door. And the guy opens the door, and he's like this Arabic guy, older guy. And he looks like all confused. Like, why? And then the guy's like videotaping it, like, and then the guy just closes the door, and then that's it. I'm like, okay, thank you for that. I love that. I could destroy you coming into the guy's home, knocking on his door, breaking his peace, just so you could videotape him. Like, what is he, a criminal? And then what do you have him doing? That he's able to open a door? We never said he's paralyzed, So it depends, right? Like, that kind of surveillance, I would throw in their face. But sometimes surveillance could be, bad. Like there was this one woman who was like throwing trees or something in Europe, and she won the contest for throwing trees the furthest or the farthest that anyone could throw them. And she had also like a back surgery, and she had a personal injury case. And I guess that was like, boy, wait, you're throwing trees, and it's like an Olympic sport. So she got nothing. So, it just depends on that. Okay, and then M says, I'm on my second lawyer who's not getting my records, Cairo PT. I'd be looking for my third lawyer. I don't know of a trial lawyer who'd be willing to take a case as the third lawyer. Do you? Yeah, well, with that kind of question, the thing is, you just have to try. You don't know until you try. Like sometimes I show a case to a trial lawyer, and even though he's the second or third lawyer, he takes it. And sometimes they don't. And sometimes I think they're going to take it, and they don't, or vice versa. So, you can't really know until you try. If you're not happy with your lawyer, you can try. I mean, I can't really tell you. Each lawyer has their own criteria, right? So some lawyers will take X but not take Y. Sometimes I get like really good cases, but see, sometimes I make this mistake. I get really good cases from like YouTube or internet, whatever. And I go to like the best lawyer, the guy who got like a $50 million verdict. And then that lawyer doesn't take the case. So then the client gets upset and they go and they find their own lawyer who's like some crappy lawyer. And then meanwhile, I had a second lawyer for you. I had a third lawyer for you. And those are also good lawyers. Maybe not, they didn't get a $50 million case. Maybe they got like a $20 million case, but they would have taken it. So, you got to find the right lawyer for the right case kind of thing. And sometimes the clients get like disheartened by the fact that one lawyer didn't take the case, but you can't really take it personally. It's just because that lawyer has certain criteria. But, so you have to just try it basically and see what they say. And Mr. Sent says, have post-concussion syndrome symptoms. I had 2 PRP shots, MRIs on the brain, neck and back, x-ray the day after the event at the ER, met via televisit with a neurologist, completed months of Cairo. So yeah, I mean, that's a good case. I mean, look, post-concussion syndrome is serious. Platelet-rich plasma ejections, PRP, that's serious. MRIs on the brain, depending on what they found. Having the MRI is not going to give you the money. It's what they found with the MRI, right? Like my case, I had a normal MRI, but the neuroquant, which compares the volume of the brain to the same age, same gender, same education level, my client had like 1%, and a lot of the temporal this, parietal that, right? I mean, I don't remember all the different parts, but a lot of them were 1%, meaning she is worse than 99% of people with the same gender, the same age, the same educational background. She's in the 1 percentile. That means 99% of people are better than her. So why is that happening, right? That's powerful evidence. Why is that happening? Unless her brain is really shrinking, which is what happens. You lose volume of the brain from the traumatic brain injury. So you could do that. You could use the neuroquant if your MRI is normal. You could use the icometrics. You could use the functional MRI, the fusion tensor imaging. There's a lot of other things, right? But yeah, I mean, it has value. It's better to do a consult. You can just text me. We can do a consult. It's hard for me to say, right? Because it's what you're saying is good, but it's very, very general. Like I don't think anyone could tell you value based on just having X-rays, having MRIs. But yeah, those are just tests that you have. But it's what the results of those tests are that really going to drive value. Plus, like how much insurance do they have, and what's the what's the liability? Where are you? Because some places, like in Virginia, I was surprised. Somebody texted me, I did a verdict search, and people are getting like $200,000 on a fusion. But in New York, people are getting like $2 million on a fusion. So it depends on where you are. If you're in Virginia, you're out of luck. You get $200,000. In New York, that's worth $2 million or more. So, all these things, it's very specific. And then M says, what would be a good way to request my records file for my current lawyer, who I believe hasn't been working up my case? You could just ask them for a copy of your file. You're entitled to it. But I mean, if you do that, right, then you're probably, you want to fire them? You don't have to fire them yourself. The best way to do it would be to hire a new lawyer and just let the new lawyer send them a letter. Because you don't want to fire them, because then what if you don't fire a new lawyer? Then you don't have a lawyer, right? That's not a good position to be in either. Okay, and then Only Pure says, is there such a thing as the insurance company tendering the policy for the full million and the policy owner coming in with more money of their own to keep you from going to trial to get an excess verdict? It's possible, but it's unlikely. I haven't really seen that too much. Usually, if they have excess or umbrella, that kicks in. But if they don't have excess or umbrella, the policy holder, like coming in with their own money, like out of their bank account, I haven't really seen that very often. I guess theoretically it's possible. Maybe a little bit, 10K or something. I haven't seen them come up with like a lot of money, unless they're like really rich and they just didn't buy excess or umbrella, and they have like millions sitting there. And Merle says, is Quick Aid good? I don't know what Quick Aid is. Enjoying the show. Oh, okay, that's good. Thank you. And Whole Roll Lotto says, Arkady, Progressive offered $16,000. The demand was $50,000. That's bad faith, right? Well, not necessarily, right? Bad faith, you have to have, it's kind of complicated to explain bad faith. Like when I write the letter, there are 10 different things that you have to have. It's a long letter. It's like a 15, 20-page letter. But basically, the short version is bad faith is if the injuries and the liability are so clear that they should just tender the 50K. Because, you have some horrible injuries, like you have a fracture, this, surgery, that. Like, there's no way this is not worth 50K. And you got rear-ended, you were stopped at a red light, and they still are only giving you 16K. Then that's bad faith, right? But you have to be able to show that it's worth so much more. And how do you show that? Well, you have to go to trial and get more and say, look, they had a chance to settle for 50, but they made us go to trial, and now we got a verdict of $1 million, so they have to pay. This is bad faith. So that's usually what it is, where they don't evaluate the risk correctly, and it's so clear, and they're just, that's why it's called bad faith. And then Arash says, what if a lawyer says she doesn't know the excess policy because she's done with the lady that hit me? What does that mean? I'm not really sure. She's done with the lady? I'm not sure what that means. I mean, you can find out the excess. Just ask them. When you file the lawsuit, you have to serve a request or a demand for discovery. And one of the things you're entitled to is the insurance. So when you ask for it, just ask for the primary. That's the main policy. And then also ask for the excess, umbrella, supplemental, concurrent, or any other policy other than the primary, right, that could be applicable, that could exist. And if they say, we don't know of any, then you could say, well, give me an affidavit of search that you searched. Give me a broker's affidavit from the broker that sold you this policy. You want to basically clean everything up and be certain that there is no policy. Sometimes there isn't any. Sometimes it's just a primary, there is no excess. But you want to be certain, so you just want to check that. And then Whole Rose says, I have trial lawyers. That's good, yeah. Trial lawyers are important. I mean, you want to make sure they're good trial lawyers. You could do a search, or I could help you do a search, and we could see what kind of results they've won in the past. And then, let's see. Yeah, I guess we went through all the questions. Okay, good. All right. So yeah, let me know if you have any more questions. I'm happy to do a few more. I think we're almost at the hour mark, 50 minutes. Otherwise, we could do another one, maybe like, let me see when. Thursday, I could try to squeeze one in. Or Friday, maybe Friday earlier. And we have a lot of other stuff. I think I did a video. It was recorded. It's probably going to come soon, where I did verdicts, and it was about traumatic brain injury, and we did a lot of different verdicts. So that's going to be a verdict one. And if you want a verdict video, I'll record a few more. I have to go into like Verdict Search or Westlaw or Lexis, some of those databases, read some of the cases. So it's a little bit more, time intensive, but I could do that, and I could do a video about, that. It could be about, like, for example, fusion verdicts. If you have a spinal surgery, a fusion in Chicago or in Miami or in, I've done New York, I think, but or some other kind of case, right? Like it's a type of injury, like a slip and fall with a, TBI in Omaha, Nebraska, whatever. I don't know if there's enough cases in Omaha, but you know what I mean? Like we could do something specific like that, or whatever you guys want. I think I did another segment live where I could actually open up the Verdict Search live, and you guys tell me, hey, a little bit about what you want searched. Like you tell me, hey, I'm in this city, I have this injury, I have this liability, and I could try to search on the spot and try to read it and analyze it for you a little bit. So we could try that as well next time. Okay. And then Shark says, if my workers' comp has been paying all my medical bills, and I've been getting 60% of my pay, can I expect a large settlement when I return to work? So they've been paying your medical bills, and you've been getting 60% of your pay. So yeah, I mean, I don't know like where you are, because in New York we do have a Section 32. So the way it works is you get your medical bills paid, you get your lost wages paid, and then depending on how bad your injury is, you can do what's known as a Section 32 settlement, which is like a lump sum. So you get a lump sum settlement from workers' comp, but then you stop getting the lost wages, you stop getting medical bills paid. They get like a credit. So, but I don't do workers' comp, so I don't want to tell you the wrong thing. The best person would be like a workers' comp lawyer. You could ask your workers' comp lawyer about that. But depending on what state, because workers' comp is very administrative, and it's not like you never have juries usually. It's not even the judge like in the Supreme Court or in the trial court. It's like this administrative judge that usually handles it. So it's all like an administrative type system. So yeah, they have very specific rules about everything. So each state would have different rules. So it would be like depending on where you are. And then Amiri says, I think my attorney is trying to settle without a lawsuit. Once a suit is filed, their fee goes up to 40%. Yeah, a lot of lawyers do that. But that's okay because they'll get you more money, so it should be fine. And then ME says, what day and what time do you do these live chats? Yeah, I mean, usually like around this time, like around 5, I try to do it. Like, I don't really have a specific day. Sometimes I do it on Tuesdays. Sometimes I do it on Thursdays. Today I was able to do it on Monday. So I just kind of do it. Like sometimes we'll schedule it and then you'll see it in the schedule. It'll be scheduled. This week, I wasn't able to schedule it. I think the person who does my internet stuff, he's away. So he's somewhere. I think he's in Japan now on vacation. So yeah, so like I just kind of did it myself. I just kind of winged it. So, but yeah, usually I think Tuesdays and Thursdays I'm trying to do that around 4 or 5 p.m. And then Mr. Cent says 3 million commercial policy in California, tow truck, post-concussion symptoms, and neck MRI showed a disc bulge. Got a PRP shot along with Cairo. Brain MRI came back without issues. Mediation next month. Yeah, I mean, like, it could be a big case. It could be worth millions. If you have a post-concussion syndrome, you don't have to have the brain MRI, like I explained, with the tip of a ballpoint pen, right? If it's smaller, you still have the injury. It's just microscopic, so you need a microscope to see it. MRI is not going to pick it up unless it's 1 millimeter, which is like the tip of a ballpoint pen. But, if you have the neuroquant, if you have the icometrics, if you have the diffusion tensor imaging, and there's other things you can do. If you have a real traumatic brain injury trial lawyer, they work it up. Mediation, just be careful because mediation, a lot of the time they want you to come to mediation, and it's like a fly trap. They lure you in, and as soon as you come in there, they lowball you. They lowball you ridiculously. Like I went to mediation on this case, they were offering me like $140,000. This was like 2-3 years ago, so I got 3.1 million. It just goes to show it's like ridiculous. So I don't go to mediations unless they give me a good faith offer. So if I'm asking for, like, say, like the second time I went to mediation, they already had given me $1 million. So I said, okay, well, if you're offering $1 million, I'll go to mediation. And then at that mediation, they went up to, I think, 2 or 2.5. And then finally in court, it settled for 3.1. So, like, I don't go to, if they weren't going to offer me $1 million, I wouldn't go to mediation a second time because the first time they only offered me 140. So don't get your hopes up is all I'm saying, and text me if you need a consultation. I could give you some good advice. And then Cole says, hi, Attorney Arkady. My case is going to a non-binding arbitration if the lawyer doesn't want to give settlement and try to pick a jury, but the judge said it's too late. What can we do? The lawyer doesn't want to settle and pick a jury, but the judge says it's too late. So it's a non-binding arbitration. So you could try it if it's non-binding. Non-binding means like it's not final, right? It's just like if you don't like the number, you could still go to court. It's just if you don't try it, if you don't like the amount they give you, just say no, thank you, and go to court and have a jury decide. And then B says, I had a slip and fall at a major car wash. When I went to grab a vacuum, fell in a puddle of water with mud. Taken by ambulance, level 3, complete avulsion of all my hamstring and left leg, had surgery. Oh, wow. Had knee injury, back injury with surgery on back for compressed disc, 2 knee injections, hip injection, gel injection, knee and sciatica. Second surgery will be in August. Yeah, so that's a huge case. It's really terrible. Make sure you have like a good trial lawyer to really work that up because that's liability issues, right? Because it's a car wash. You might need to get like an expert, somebody who knows how car washes should be maintained properly and safely, but also doctors. And then you probably need also like either a life care planner or at least an economist with a doctor that's going to give you future medical costs, because with all those surgeries, you're going to need future surgeries, future prescriptions, future, physical therapy, future MRIs for the rest of your life. I don't know how old you are, but that could be huge. Just the medical costs could be like 2-3 million on a case like that. So yeah, feel free to text me also if you need a consultation. 347-566-9595. I'll try to do a few this week because it's, I freed up. I still have a lot of work to do, but I'm going to try to make like at least, 1 or 2 every day this week. And then Boriqua says, I texted you 2 weeks ago from your latest live. I never got a response. I want to know if you can take my case. Oh, yeah, probably because I was on trial. Just text me again. Yeah, text me again and I'll respond to you. Now I'm free, so I'll try to help you. Maybe I can chat with you tomorrow, in fact. Tomorrow I'll be in the office early, so I could speak with you, and I'll try to help. I'm sorry about that, just because I was on that case. And then JC says, are you able to represent clients in other states? So the way I do it is, I partner with, I co-counsel with a local lawyer in other states. So they have primary responsibility. Now, if they and the client want me to come, like if there's a trial and they want me to like come and do the trial with them, I can consider that. I can do that. But I'm admitted in Texas and I'm admitted in New York. Those are the two states I'm admitted in. But I don't really practice in Texas. I just went to law school there. I went to UT Austin. So I took the bar, I passed it, so I have my license there, but I don't. And you can waive in to a lot of states. The only place you can't waive in is, I think, Florida and California. But you could pro hoc it. Pro hoc is just for one case. Waive in would mean you waive in and now you're a lawyer there for everything, right? Like anyone else. But pro hoc vice means that you're just coming in like for one case. And that usually they approve. So yeah. And then Freddie says, we talked and my lawyer had me sign a POA for medical pay, but I haven't heard from them for about 2 weeks now since we last talked. Yeah, I think I remember Freddie. I remember him speaking. Yeah, just text me. We could chat again. I'm happy to chat. And B says, I'm 62 on Social Security disability already. All right. Yeah, so even like 62, but people look to be like 85. So you got like, say, 25 or whatever years, 23 years. Medical costs in those 23 years could be like 3-4 million easily. Like I had a 57-year-old with a single level fusion, and just the medical costs were 2.7 million. So yours probably, with these surgeries, probably worse than having one single level fusion. So you're talking about hamstring with avulsion. That's terrible. That's serious stuff. And then ME says, what if the med mal doctor does not have an expert to back him? Well, I'm not sure what you mean, a med mal doctor. You mean if you're suing a med mal, you're suing a doctor, a defendant? Or I'm not sure what you mean, a med mal doctor. There's no such thing as a med mal doctor. There's a med mal lawsuit against the doctor, whether the doctor's the defendant. There's also a med mal expert. If I'm the plaintiff and I'm bringing a med mal lawsuit, med mal is medical malpractice. So I'm basically saying there was medical negligence. A doctor did something wrong. So either I'm suing the doctor who I claim is doing something wrong, then I need an expert, right? You can't sue them without an expert. You're going to get dismissed. Or, there's the doctor that is being sued. So I don't know what you mean. But there's no such thing as a med mal doctor. But yeah, you always need an expert. It's med mal. You can't. How are you going to prove the case if you don't have an expert? It gets dismissed. You can't just say, I think the doctor did something wrong, because it's medicine. So you need to have a doctor that reviewed all the medical records, reviewed the file, will come to court and say, I swear to a reasonable degree of medical certainty that this doctor, the defendant, did something wrong. It's called a departure from good and accepted medical practice. Basically, good and accepted medical practice. Good practice is here, but the doctor was here. He deviated, right? He was under and lower than good and accepted medical practice. That's what you need. And not just that he made a mistake, but that the mistake caused the injury that you had. Causation, too. You need both. Med mal are really hard. I don't do that many unless it's something really, really serious. You can't really take small med mals. It doesn't make any sense. You waste $100,000 and you get zero. Med mals are hard. But that doesn't mean, there are good med mal cases out there. And then Mr. Sen said they denied liability initially, then lowballed me $15K. Is my lawyer bad for offering to go to mediation in response? I mean, $15K, yeah, I wouldn't do it. I mean, if you're looking for, what were we looking for? Like, I'm sorry, because I read a lot of comments, but I think you were saying $3 million or something, right? Is that the case with $3 million? I mean, look, if they're offering $15K, you're not going to get $3 million. They're going to offer you $30K, $40K. You gotta make sure that you have a real trial lawyer. The best thing to do is just text me. We could chat. We could get a lot further. You know what I'm saying? Like we can get to the heart of the issue. I can help you. Here, like on a general YouTube, I mean, I'm happy to answer it, but it's more like general stuff, right? I can't really get to the heart of the issue and help you the way that you need and the way that I think you want. But yeah, just text me. It's free. I'm happy to help. And then Romaine says, my lawsuit against USPS just started a year after the accident. What is the process and steps? Yeah, so I mean, look, that's a big question. I mean, I've done videos where I talked about the legal process. Basically, you file a lawsuit, they answer, you go to the judge, you do a preliminary conference, you talk about discovery. Discovery, briefly, is exchanging medical records, exchanging documents, both sides, right? And also doing depositions of the parties as well as possibly non-parties. Once all that is done, then you go on the trial calendar, then you have the wait, then you have the trial. So that's a really brief answer. But I've done other videos where I think it's like a 7-video series, and I go into every, every part, because there's the investigation stage, right? The investigation stage is here, right? Or then you go from the investigation stage to the lawsuit stage, to the discovery stage, to the note of issue stage, to the pretrial mediation, pretrial conference, subpoenas, whatever, trial prep, and then the trial. That's like the last stage, right? So it's a whole process. I think I did like 7 videos about it. But yeah, you could check that out. And the defense lawyer wants to go to mediation. Is it bad to go? Well, I mean, it's not bad to go. It's just don't get your hopes up. They might give you nothing, or they might give you like 15K, or I don't know. I like to get a good faith offer. I don't like to waste my time, because mediations in New York, in Manhattan, they cost money. A mediation, the judge wants $600 an hour, then they get a bill for like $2,000. I even made a joke. I said, and what do you get? You go there, or sometimes they even do it by Zoom now. But say you go there, they have a bunch of pens lying around, so you get a free pen. It's a plastic pen. It's not worth $2,000. And if I don't have a real offer for my client, how do I justify wasting my time, getting demoralized and being told my case sucks, and breaking the relationship between me and my client, right? Because the client's gonna be like, why did you bring me here? Why couldn't you have found out what they're really offering? So then I look like the bad guy, right? All these problems. And then I made a joke. I said, I don't need another $2,000 pen. I have enough pens. But what do I get out of it? Like, unless, like in my case, okay, they offered me $1 million. So I knew, okay, $1 million's on the table. We're going to talk, between $1 million and I think we were trying to get 4, and we ended up selling for 3.1. And then at the mediation, they got up to 2.5. So I could justify, okay, I paid $1,000, but look what I got. I got a result, right? So that's the issue, right? Is it likely to lead to a settlement? If no, then don't go. If yes, then sure, go. I settled a lot of cases at mediation. I had another case actually last week. It didn't go to mediation, but it settled in court. It was up in Rockland, which is a conservative venue. It was a car crash with Fusion. They had 1.25, right? That's 250. It was a 250 with $1 million excess, or 1.2. I think I forgot how it was structured, but it doesn't matter. They had 1.25. That's all they had, 1.25. Same thing. I sent them a letter. I said, pay me the 1.25. If not, I'm going to go to court. It's going to be like $4 million. The lady had horrible injuries, Fusion, this, that. I'll do a video about it. Very nice lady, interesting case. I haven't had a chance to, I have to review the file, do a video about it. Another lawyer from my office was there because I was on trial. She settled it. But like, it settled for 1.15, almost the whole thing. I mean, I wanted the whole thing, but they were just, being ridiculous. But whatever, the client wanted it, so we settled it for a little less. But it's $1,100,050, $1,150,000, and all they had was $1,250,000. So we gave them a gift of $100,000. Like I always say it the opposite way. The judge was laughing at me because when I showed up and the judge was trying to settle my case, the judge goes, "What do you want for this case?" And I said, "Judge, I want like 4 million or close to 4 million, because then guess what? Because they had $1 million, but they had 5 million in excess and umbrella. So I said, Judge, I'm saving them $2 million. Aren't I a nice guy? I'm letting them walk away, saving $2 million. The judge loved it. He was laughing. He used to be a plaintiff's lawyer and try cases. So he was like, I love it. You're saving them $2 million. It just depends on how you look at it, right? So that's how I look at it. This case, I saved them 100,000, right? Because I got 1.15 out of 1.25. So yeah. So let me go back. I have to run actually. So let me finish these questions really fast. So okay, I'm sorry. So then ME says, I'm suing a doctor, but he has no expert to back him. Oh well, yeah. If you're suing him and he doesn't have an expert, well, he could be his own expert. He could say, I don't think he needs. Well, better for him to get an expert, but if he doesn't, if he wants to be his own expert, he could, I suppose, say like I'm good. a good doctor. I you know, adhered to the standard of care. I didn't deviate. He could say that. But if you have an expert and your expert is credible, you should win. It's not automatic, but it's whoever they believe. But it's better for you, right? If you have your case and then you have your expert, and then he's his own expert, especially if he's not a likable guy, well, you're gonna crush him. And then Billy says, do you ever see surveillance before deposition? I have mine next week. Very strong case with herniated disc and court-required mediation the following week. I mean, sometimes, yeah, I've seen it. Usually it's after deposition because they want you to, do something that you say you cannot do, because then you're lying. It's all about credibility. These cases are all about believability, right? Being credible, being believable. If you're not credible, then it's like falsus in uno, right? If you're lying about one thing, you could be lying about everything, then it's like a house of cards, your whole case collapses. So that's why it's very important to be honest and be credible. Okay, and then the only czar says, my car broke down on the highway. I had my hazard lights on. It was in the lane I was parked. I was going to try to move it out of the lane, but before I could get out, I got rear-ended. Now they're trying to shift blame. Should I go to trial? I mean, if your car broke down and you had your hazard lights on, you were parked, and you were going to try to move it out of the lane, but before you could, you got rear-ended. So I'm assuming you got rear-ended while you were in the car. So it's a good case. You got rear-ended. Your hazard lights is on. Well, why are they rear-ending you? And if your car broke down, well, how can you have moved it? How are they going to shift the blame? I don't understand. What are you supposed to do? Be Superman? If the car run away? Like, how are you supposed to move it? Like, if it broke down? I think that's a good case. I don't know. Well, you just have to think about it logically. Like, what did you do wrong? If your car breaks down, that's what you're supposed to do, right? You put out the triangle, your hazard lights, you get out, or you can stand next to it. But I don't see that you did anything wrong. And Billy says, my lawyer told me a year ago, early on, my medical bills were around $33K, but I called my medical funding case manager, and she told me my medical bills are around $21K. Did the insurance pay some of my medical? I don't know. I mean, it's possible. It could be that somebody's wrong, or it could be that the insurance paid some of it. You have to ask the lawyer. I wouldn't know, right? Like your case file, because that's very specific. It's like, I read the case file. I don't want to tell you the wrong thing. It'd be like, yes. Okay. Thank you so much. I have to run, but this was good. We answered a lot of questions. We were here for an hour and 12 minutes, and we'll be back maybe later this week. I'll try to come back. Please like and subscribe to our channel. If we gave you a consultation, please leave us a review. We have that in the link in the description. You can leave us a review. That's really helpful because reviews allow us to then be seen, like on Google, so that people in New York, when they're looking for a lawyer, they see us as opposed to seeing one of those like White Castle lawyers or whatever. And they get to the wrong lawyer, and then they don't see us because we don't have that many reviews. So I was asking anyone that we've interacted with, like if you ever texted me, called me, or you could just leave us a review. It takes like 5 seconds. That's really helpful. But otherwise, just like and subscribe to our channel and let us know what videos you want to see in the future, and we'll do it for you. Okay, everyone, have a great night. All the best, everyone.